Want to welcome you and thank you for joining us today for our lunch presentation on estate planning, not just for the wealthy. Estate planning is essential no matter what the size of your estate. It is a way to safeguard your assets and your beneficiaries' future. Our experts today will cover family emergency binders, wills, trust, and gifting, and some more topics. I'm Carolyn Powell. I'll be your host today to get you started. Just want to touch on some quick housekeeping. We do have a couple things in here for you today. In the handout section, we do have a copy of today's presentation. You can go in there and download that, and also the bios of our experts. There is also a question section in your toolbar to the right. You can pop in questions throughout the presentation. Let us know what your question is. We'll get it answered either during the presentation or at the end. Also, you can too put in there what you're looking to accomplish today, get information on, let us know what that aha moment was or that big takeaway that you're going to go follow up on. At the end of today's presentation, you will get an immediate survey. If you could please fill that out for us, let us know how the presentation was, and if you'd like a meeting set up with Adam or Lisa. And then this afternoon, I will also send out a copy of the slides again and a link to the recorded session. So if you want to go back and re-listen to anything or share it with somebody that wasn't able to attend, you'll be able to do that. And again, I will send that out this afternoon. So without further ado, let's get started. Tronconi, Segarra and Associates is a certified public accounting and business consulting firm. And our two experts today are Lisa Mrkall and Adam Ohar. Lisa is a CPA and partner here at the firm in our small business department. She has over 10 years experience with the firm and is also an adjunct professor at the Niagara University. She has a diverse client base, different industries and individuals that she works with. Adam Ohar is a CPA and principal here at the firm in our tax department. He has over 15 years of experience at the firm and also has a diverse experience with estate and trust, multi-state businesses and consulting, and also dabbles in the non-for-profits world. So he's got a lot of different background here. Before I hand it off to our experts, I'm going to do a quick poll so they can get to know you a little bit better. And let me just get this up here for you. So the question is going to be, I currently have, and then if you could just fill in your answer, that'll help them understand a little bit more of where you're at in your planning. I'll just give this a minute. It's a three-way tie going here of where people are at. Which one is it going to be? Give it just another minute for you. Right, I'm going to close it out in 3, 2, 1. Just kind of share the results with you. So kind of mixed between, I have some things in place, but not all. I know I need to do this, but haven't done it yet. And 22% of you have estate planning in place. So that's great to hear. And hopefully for those that are in the midst of it, we can get you finished up today or get next steps going. So at that, I'm going to hand it over to Lisa to get us started and take the presentation away.
All right, thanks, Carolyn. Again, my name is Lisa Mrkall, and thanks for being here today, everyone. We'll start out with our agenda. We have a lot of information to cover, so we'll get started right away here. We'll cover some very basic terminology and topics, very basic, but as we have learned, Adam and I, our clients and their families deserve and need to understand these basics about estates and trusts before we build on them and enter into more sophisticated discussions about specific planning needs and tools and situations. Adam's going to cover the nuts and bolts of estate tax and trust in more depth, and we'll both be taking questions during the presentation and at the conclusion. So first we have what is an estate, or what is estate planning? Estates and trusts are often confused with one another, these terms, but they are both very important and primary components in the estate planning process. An estate includes all of the assets someone owns or has a controlling interest in at the time of their death. This may include land, personal property, real estate, cash, cars, bank accounts, investments, collectibles, furnishings, art, antique items, insurance policies, and jewelry. Estate planning itself is the multi-generational transfer of wealth and is the process of laying out how you want your assets handled at your death or in the event of physical or mental incapacity. Estate planning has become one of the fastest growing areas for us as advisors here at Tronconi-Sagara. It's an extremely important area for us, and there's more demand than ever for comprehensive advice in this area than ever before. So something we'll talk about today is that our clients, as our clients' lives evolve and go through life stages and changes, we are quite often the professionals they reach out to first for this advice. There's really just a built-in level of trust already, simply because of the relationship that we already have with our clients and the services that we perform for them. So we take that very seriously. The stages have to do with getting married, having children, buying your first home, and how a lot of these are areas we can help with. So why do we do estate planning? Why do we do this? Why do we need this? So there's a common misconception and assumption about estate planning that we hear from our clients all the time and about who needs to do this. So basically it's that their level of assets may not warrant an estate plan. It's a very common misconception, or that they are just not ready for it. Could be someone in the early stages of their adult lives and asset accumulation, but they also may have kids. So the purpose becomes protecting our loved ones. Obviously, at the effective transfer of wealth and assets upon death, naming guardians for minors or dependents, and incapacity protection. So just along those lines, this one in particular is often not thought about nearly enough, but it happens all the time, unfortunately. There's accidents, health issues that we all have to be prepared for. So the importance of providing education here. For example, do your children know what would happen if there's an accident and something happens to the parents? The education piece really becomes very valuable, and about what would happen to you in your scenario if you don't have an estate plan in place. Obviously, charitable intent, tax control, and tax planning areas we heavily focus on here at Tronconi, as well as business succession, since so many of our clients are owners of businesses and of many shapes and sizes. Some have family to take over their businesses and some don't. Preservation of wealth and distribution of assets are some areas we'll start to touch on here too in terms of the basic concept. So what is a will? I think most people are familiar with this document in that it's going to say what happens to our property when we die. But it does some other important things too, like designating the person in charge of carrying out that plan, the personal representative or the executor. It's important for people to have a will, because if they die without a will, they are said to have died intestate. And in this case, it's where your state's laws will dictate who gets your assets. So it's really a missed opportunity if you don't have a will to say what happens to your property or who specifically gets it and who's in charge of carrying out that plan. Okay, so administering a will. So Adam will dive deeper into this, so I will be brief here. All wills have to go through probate, which is a process of probate administration, which is a court process. A judge determining if a will is valid, that the will is something that somebody left behind, that it was intended to be made and was genuine. Once the judge determines that it is valid, they will in turn order granting powers to the person nominated in the document as an executor or personal representative. The role of the executor is to take that original will to the probate court, gather assets once they've been appointed. So they don't then just jump right into the distribution of assets. So that's a common misconception. There's a lot of pressure. A lot of times we see from beneficiaries who have that anticipation of an inheritance. This is a job, the executor. First and foremost, they have to pay debts, final expenses. That's the less fun part, and taxes, of course, that are due, and then and only then, after those taxes are done, do they distribute what is left over. So to this, we say every adult needs an estate plan. We each actually have a default estate plan. We just might not be happy with who is in charge of stepping in to manage our affairs. So all the more important to have a plan. If family members are separated by geography, and you want to know who can realistically step in at a moment's notice, especially when families with younger children are involved. So it's important to take the time now to dissect that plan and make sure it's something that you're comfortable with. Okay, so just a couple more of these basic sort of 101 concepts. What is a trust? A trust is a legal agreement between a settlor and a trustee. It is simply an arrangement by which one person holds legal title to an asset and manages it for the benefit of someone else. A person who makes a trust is called a settlor, or more common, the grantor, the person who makes the trust. And these terms are listed here on the screen. The trustee is the person named in the trust to manage the trust and carry out the terms. The beneficiary is simply the reason for the trust, the party or parties who receive the property. And just very quickly, the benefits of a trust is, one of which is probate avoidance, gives you a little bit more control over assets, the when of the distribution, and a little bit more complexity with regard to tax planning. So this is also a very powerful incapacity planning tool as well. Okay, again, Adam's going to get into these a little bit deeper, but I'll just cover them briefly. These are certainly not all the types of trusts. The third one is an umbrella term. Many tax planning trusts fall under this term. The most common type of trust you'll encounter is the revocable living trust. It is the one created while you're alive. It can be changed or revoked, and it's the main reason people use it is probate avoidance or delays of probate. So all wills go through probate, as we stated earlier, but the benefit of a fully funded revocable trust is probate avoidance for any assets placed in the trust. The terms of the trust control what happens to the assets, and generally, again, designed to go through probate. Testamentary trust is embedded in a will. So sometimes it's used when someone does not want to go through the additional expense or process of setting up a trust. Setting up a trust requires a little bit more planning in the now, whereas with a will, we can kind of put off some of that expense and headache. Testamentary trust, whenever you die, it creates a trust in the will for your beneficiary, so it becomes effective at death. Whereas the revocable living trust, setting it up right now, is effective right now. Again, the tax planning trusts, an umbrella term category is mostly irrevocable trust. You'll see a lot of acronyms to describe or list out several different types of trusts in the tax realm, special purpose tax planning tools here. Certainly not as common as with the revocable living trusts. Certainly another very important category is the special needs trust. There are beneficiaries with special needs out there. So these special needs trusts help preserve certain important public benefits that they receive that may be means tested. So if a beneficiary with special needs were to receive any kind of inheritance, even in a revocable trust, it's treated as though it were in their hands and means tested public benefits to any resources. Too many assets or too much income can disqualify them from receiving those benefits. So the special needs trust is set up to navigate that and ensure it can supplement those needs without losing those public benefits. Okay, when to consider a trust. So this is a good one to spend a little bit more time on. We get a lot of questions on this. Our clients are often going through one or more of these stages in life, having younger children. This is an important planning moment where you might not want the children to come into an outright distribution or inheritance. They're not capable of handling that in many cases. So naming a trusted family member or fiduciary to manage that if the worst were to happen, and instead of that windfall inheritance going to the young child. So these can be staged or have staggered distributions, age-based, based on certain incentivized conduct, certain milestones, maybe having to do with education, trade school. So complex families. Divorce is very common, so it's a planning moment that needs a lot of consideration, as does getting remarried. We do encounter the not uncommon scenario of wanting to provide for the current spouse, and there was wealth accumulation before the second marriage, and there are children from a previous marriage that you want to be the primary beneficiaries. A trust does enable you to do that, to say provide for the needs of the spouse, but ultimately wanting the children to receive the bulk of the inheritance. So as I mentioned earlier, probate is a court process, so that means it is a public process. Anyone can go and see what a will has said, who were the beneficiaries, what sort of assets were left. It's part of the probate process to prepare an inventory of assets reported to the court, available just by checking the probate records. So privacy is important here in terms of preparing the trust, one of the key benefits. With trust, we intuitively believe that these are tools for the wealthy. In a particular state, probate costs can be a percentage of assets in the estate. So this is also a useful tool for tax minimization. Okay, funding a trust. So these are general concepts with regard to titling of assets. For taxable accounts, ensuring that beneficiary designations here work really in concert with the terms of the trust and are not in conflict with each other. So you'll need to know where to find the right forms for designating the beneficiary. We can help with that. Retirement accounts are often a large piece of our client's wealth. If they're married and that the spouse is named as the beneficiary. If minor children are in the picture, appropriate conduit trusts set up so that those are properly set up as alternative beneficiaries. So setting up the trust is just one step. Actually funding it is another, but it is a relatively easy, actionable thing to do. On my next slide here, I really won't read anything here. This is really just a nice at-a-glance slide. Probate avoidance being a big one here, control over assets, more granular control really with the trust. And a will, to note, it's just not operative until we die. A trust is something that's set up now, such as that revocable living trust. Okay, so I'll go through this slide quickly as well. It is an important topic. We do see the detriment of not having certain things in place quite often. So these are some documents that, there are obviously a lot of documents that cover assets and wealth distribution, but these are also extremely important as well. So we plan for the inevitability of death, but we're not always as good as planning for the inevitability of sickness, disability, or incapacity. So these documents allow someone to step in and get access to medical records, such as the HIPAA authorization, is what we're referring to there, discussing treatment decisions with providers, knowing what my prior decisions were with my providers. Advanced healthcare directive is a document where I get to specify what I want my end-of-life care to look like, which is taking the guesswork out of those critical decisions. Power of attorney. So financial power of attorney is probably one we're all pretty familiar with, naming an agent to make financial or business decisions for me when I'm incapacitated, more or less anything there that isn't medically related. Okay, so just a couple practical tools here for keeping important family information organized and at the ready. We've heard this called many things. For our sake today, we'll kind of call this our family emergency preparedness binder. It's also been called a family contingency binder, end-of-life planning guide. These are available for free and of course for purchase from anywhere from Etsy to Amazon. A friend recently shared this resource for me. It's a book that is actually in the corner of the screen there from the AARP and the American Bar Association. It's a softcover book called Checklist for My Family. And so this really does help you document important family information, family history information, financial plans, final wishes. Does not take the place of a will. I want to make sure we mention that. Can't really stress the importance enough of this task for your family. It's really not a all or nothing kind of project. Something along these lines is certainly better than nothing when it comes to sparing your loved ones from having to make stressful decisions and frustrations when one is ill or upon death. So you can also add an endless list of your family's critical documents, but it's just a nice kind of one-stop shop for all kinds of vital information in the event of incapacity or death. Lots of good checklists and tools, filling in important information, anything from burial wishes, organ donation, and even caring for pets after death, for example. If you would like to see some examples of some of these checklists, we have several at the ready, and you can just reach out to me, and I'd be happy to send those to you. Okay. So as CPAs and tax professionals, we would be remiss if we didn't mention at least one tax form today in our presentation. So we want to mention some key tax forms that need some special attention in the year of someone's passing, and some additional forms that may need to be filed depending on the estate and particular situation. So a form we're all very familiar with is the Form 1040, the federal income tax return. In the year of someone's death, the deceased person's final income tax return needs to be filed for the period covering the beginning of that tax year up through the date of death. So this includes all the income, deductions, credits applicable to that person. The final individual income tax return is due on April 15th of the year following death. Next, we have the Form 706, or the estate tax return. If the deceased person's estate is large enough to trigger federal or state estate taxes, the personal representative executor may have to file an estate tax return. Filing Form 706 captures the unused exemption of the decedent if their spouse survives them. This return reports the estate's total asset value and calculates any taxes owed, and it's going to be due 9 months from the date of death if it's required. We definitely wanted to mention this Form 1041 today. So a lot of executors don't realize they may need to file this form. It is the estate income tax return. That's one of the uses of it. So if the decedent's estate generates income after death before the assets are distributed, an estate income tax return may be required. So this is typically applicable if the estate's gross income, I want to stress that, exceeds $600, so it's fairly low. It covers the period from the date of death until the last day of the month before the first anniversary of death. So the income tax return for the estate is due on the 15th day of the 4th month after the close of the tax year. And with any of these forms, these are certainly things we can help with and answer any questions on if you have concerns as to whether or not you or your loved one's estate would have at least $600 in income. So then we have the gift tax return. We get a lot of questions on this topic. This is the federal Form 709, and is filed if an individual makes gifts during the year that exceeds the annual gift tax amount, or if the gifts exceeded the lifetime gift tax exemption. Again, happy to answer any follow-up questions on that too. So these are some forms I wanted to mention today. It can get very overwhelming very quickly, but having a team of professionals, trusted advisors, can't be stressed enough during this process, from attorneys to assist with wills, estate administration, and legal complications, financial professionals to help manage those affairs and ensure everything is handled and filed properly. So that team is really going to provide crucial support to you and your family and expertise during a challenging and certainly emotional time. All right, so now we have the countdown for gift and estate tax exemptions. Coming up at the end of 2025, January 1st, 26, it is expected that the exemptions that are doubled now will go back down to the normal inflation adjusted amount. So the amount will vary, but it's expected to be 7 to 7.5 million, doubled for married couples. So for our wealthier clients, it's an opportunity for clients to talk perhaps about making some one-time gifts to take advantage of that increase now before losing the opportunity to use it later. Again, we can't stress enough the importance of avoiding this year-end flurry next year in 2025. Contact an attorney sooner than later and get that much needed, tailored advice for your particular situation. And whatever you can do, to be comfortable with giving away in terms of assets and also control. Important discussions to have. Okay, I know we're coming up on time here, so I'm going to probably have to speed things up a little bit. When to update your estate plan? Certainly here we have those life stages, but really, your estate plan is going to be very different at age 18 versus age 65. If you have a substantial change in net worth, these major life events, divorce, big change in net worth, buying a home, moving states, certainly is something we've seen a lot over the past 3 or 4 years. Having children. So of course, having a legal guardian appointed is very, very important. Who needs an estate plan? Really simply stated, everyone. Every adult needs an estate plan. Age 18, I mentioned that in the previous slide. When children go away to college, they're 18, they're 19. They need to have those incapacity planning documents. Have heard some really unfortunate stories along these lines. A trusted family member does need to have power of attorney over them if something bad were to happen. Important planning moment for the family at age 18. So other popular motivators, again, marriage, children, accumulating assets, medical concerns, all reasons people think about estate planning. Okay, so I could elaborate a lot more, but again, in the interest of time, I'm going to pass things over to Adam now. He's got some great reasons for estate planning for those with modest wealth and great topics, so take it away, Adam.
Thanks, Lisa. Hi, everyone. I think I have about 20 minutes left. My name is Adam Ohar, as Carolyn mentioned at the beginning. I've been here for 15 years and have extensively worked in our trust and estate practice area. And over the next few minutes here, we're going to dive into a few things. Why estate planning is needed, a brief overview of the federal and New York estate tax system, the probate process and how to avoid it if that's an interest. And then we're going to run through a couple types of trust, some of the definitions and some of the unique provisions you can include to give your beneficiaries and trustees more flexibility. So reasons why estate planning is needed. Most people normally won't have a federal taxable estate. In the next slide, we'll do a quick overview of the federal estate tax system, as well as the New York estate tax system. However, certain states impose an estate tax themselves. I think there's about 7 currently. And the issue living in New York is that the exemption is about half of what the federal exemption is. And there's also some key differences that make it a little bit more of a unique process to plan for. So if there's people out there who assume they don't have a taxable estate because they're hearing about the federal exemption, it may not be the case for New York. Asset protection, that's one of the most important aspects of estate planning. Some peace of mind that a beneficiary won't lose their inheritance. We will also talk about this in a couple slides through the use of spendthrift provisions that can be added to trust. You may need to provide for a surviving spouse, make sure they have access to income or assets so they can keep their current lifestyle after the death of a spouse. For persons who are on the second or more marriages, estate planning ensures that children from a prior marriage will be taken care of and not left out of inheritance with improper planning. Medicaid planning, that goes hand in hand with estate planning. Everyone wants to ensure them or their loved ones will receive the proper care they require as they get older. Planning could be a mix of, buying long-term care insurance or planning in advance to ensure Medicaid eligibility. So a person's assets are not completely wiped out during end-of-life care. With Medicaid planning, advanced planning is key here because the 5-year look-back period you have to satisfy in order to establish your Medicaid eligibility. So if that's a route you need to take, I would encourage you to act as far in advance as possible to make sure you can satisfy that 5-year period. If philanthropy is important to you, estate planning will help you meet those goals. Most importantly, you get to decide how your assets and wealth are distributed. You don't want to leave this process up to the state or an appointed representative of your estate. You decide the who, how, and when for your loved ones receiving the assets. Many other reasons, these are just some of the main ones. It might take a carefully crafted estate plan to care for family members with drug and alcohol addiction, protect them from themselves at times, and ensure their inherited assets aren't depleted after you pass away. Long-term planning, we just talked about that. Caring for minor children and even pets, that's not as uncommon as you would think. So we'll run through a brief overview of the federal estate tax system, and at a high level, it's essentially an excise tax on the gross assets that you have, your net worth, upon your death. the large majority of people won't need to consider the federal state taxes in their estate planning. So with the Tax Cuts and Job Act, we've all heard about this greatly increased exemption that everybody gets. And for 2024, that amount is approximately 13.6 million. For a married couple that, you can plan with both of those figures, that's just over 27 million. And the way the federal estate tax system works, you can either wait to die, use this exemption, or use it now through lifetime gifts. The decision to when to use that exemption is complicated. We'll talk a little bit about that because basis planning comes into play here, removal of future appreciation of assets. So it might be time to, if you might be running into an estate tax problem, consider giving those assets away now. And we have a lot of people who, absent the estate tax planning side of it, they want to give their loved ones or their kids the money now instead of waiting for them to die because it's more impactful now. They're just starting their lives. The parents aren't going to need it. So we have a lot of people, who do want to transfer a significant amount of wealth now, even if they don't have a federal estate tax problem. As Lisa spoke to, the sunset is coming. The TCJA increased this exclusion. It's set to expire by the end of 2025. We don't know what's going to happen unless there's any, future legislation. We have a new president coming up, so that's going to throw a curveball and into a lot of planning situations. So yeah, it's you don't want to wait though. I mean, if it does scale back, it's a use it or lose it kind of situation. And if you think you might have a federal estate tax problem or New York, which we'll cover next, it would be best to probably get in touch with an attorney or an accountant now because they're already starting to be overbooked and you don't want to get in a situation and wait until this time next year when nobody is there to help you. All right, if the lifetime credit does revert back as scheduled, as Lisa mentioned too, it's set to go back to 5.6 index for inflation, and many believe that will land at approximately 7.5 million after it's indexed for inflation. The current annual gifting exclusion is $18,000 per beneficiary. Married taxpayers can elect gift splitting, which would bump the annual amount up to $36,000 between the both of them. So if a husband and wife would like to make a gift to a child who is also married, they can, in reality, actually give $72,000, $36,000 going to the child and $36,000 to the child's spouse. And any gifts under and up to the annual exclusion will not affect your unified credit, your lifetime exclusion of the 13.6. These are completely free from the federal transfer tax or gift tax purposes. The one we're getting into some tax knowledge here, and I alluded to some basis planning earlier. The one caveat in all this, which requires some special planning, is that gifts made during life will not be afforded the date of death step up to fair market value. So if you die, you didn't do any lifetime gifting, everything is transferred through your estate upon death. The assets will receive a stepped up cost basis, which would generally eliminate any income tax considerations of those assets in the hands of your beneficiaries. However, if I decide to make a gift while I am living, I want to give part of my investment portfolio away to my kids. If it's a lifetime gift, I'm going to have to utilize some of my exemption, but the donee will not be afforded that stepped up basis. They will then incur my carryover basis for my original purchase. So there really has to be a good blend of careful planning here because you do want to limit yourself from estate tax exposure, but you also want to preserve the step up and eliminate any income tax considerations. So the benefits of making those gifts now, it'll remove future appreciation from your estate. If you give away $3 million now and those assets over the next 10, 15 years grow to $20 million, I made a good choice. All that appreciation is out of my estate and all it cost me was $3,000 of my exemption. Another reason is uncertainty of future tax legislation. The estate tax laws are usually always in the crosshairs of new tax legislation. We're already seeing some of the effect now with the higher lifetime gifting exemption set to revert back to nearly half of what it is. So a wait and see approach might not be the best, and it might be wise to really take action now and take advantage of the highest estate tax exemption we've had in our history. As I said earlier, the vast majority of taxpayers might not have a federal estate tax problem, but New York's a little different. And, you know, there could be a lot of residents that may, you know, have a New York estate tax, and the planning for New York is a little bit different because the federal system the New York system has some large differences compared to the federal. So the estate tax exemption is 6.9 million. The one difference here is that this is a cliff tax. Once a taxpayer eclipses the exclusion, the entire state becomes taxable from $1. So if I die with $7 million, I'm not just taxed on 60,000, I'm taxed on the full 7 million. For federal purposes, if I died with 14 million, my exemption comes off that, and I'm only taxed on the net amount that's left over. So that's going to create, you know, some problems potentially for married couples who have wealth of somewhere around $10 million. It might require some advanced planning. Another huge difference is the New York estate tax system does not offer portability. And what portability is if the second to die spouse of a married taxpayer is able to absorb the unused federal exemption from the first to die spouse. So I'm a husband and wife. I leave all my assets to my spouse. I don't have a taxable estate due to the unlimited marital deduction. In this case, the wife will pick up all the assets. She will have that as part of her federal gross estate. She will have her own exemption, and for federal purposes, she'll also get to use my unused exemption. So with the current estate laws, I leave everything to my spouse. Presumably she dies, you know, next year. Let's just keep the rates uniform here. She'll have about 27 million to use as a federal estate tax exclusion. New York does not offer this. It's a cliff tax and it's an exemption. So if a husband and wife have a net worth of approximately 10 million, as we stated, really no federal estate planning is needed. The assets will pass to the spouse, the unused exemption will follow. The second to die spouse will now be able to utilize that full exemption. In New York though, if I leave everything to my spouse, she's gonna take $10 million. She won't be able to use my New York exemption, and when she passes, she's now stuck with a $10 million gross estate that, due to the New York State cliff tax, the entire amount will become taxable. And we're going to talk about a few planning techniques, mainly the credit shelter trust, which is extremely popular planning mechanism, and it's really a way to freeze the asset values and in a backwards way really maintain portability for New York purposes. So if you're sitting around that, you know, $6 to $10 million of assets, and there's no planning has been done so far, I think a credit shelter trust or some form of that is probably prudent here. Some good news is that New York does not have gifting like federal does. If you make lifetime gifts, you need to start drawing on your exemption. It won't impact the New York exclusion of the taxpayer upon their death. However, you can't wait until the end of life or make deathbed gifts, as they call it, to avoid New York estate tax exposure, as any federal gifts made within 3 years of date of death are going to be clawed back to your estate. So you can't wait for there to be a health event and then rush all this gifting through. You need to satisfy the 3-year rule, or all that gifting and all that planning might be unwound. Okay, so we're going to talk a little bit about the probate process. You know, generally it's talked about as a negative for estate planning. There is some positives to it, and it will provide legal oversight over a will, which, you know, it can be a benefit. But for the large majority of people, there is always a push and a concerted effort to avoid probate if they can, and whether and when it makes sense. As Lisa talked about, probate is a process governed by state law, and it's essentially the legal process of proving a will that occurs after the death of a decedent. In New York, this is overseen by the New York State Surrogates Court. If someone's estate planning starts and ends with a will, while it's great, their assets will be distributed in accordance with their wishes. It will take months, or in some cases years, until the probate and complete administration process can be completed. especially now, the courts are backlogged quite a bit. And this could, have some negative effects to it. It could have delays with the beneficiaries receiving their assets. Some other cons of probate is that probate proceedings are part of public record. Details of the decedent's estate will become accessible to the public. And probate's expensive. There's court cost. In addition, the executor and attorney fees, in some cases, can generate their fees off the amount of assets that have been probated. So if there's reasons and assets make sense to avoid probate, it likely makes sense to do those. And we'll talk about a few of those in a little bit. So there's a few methods you can use to avoid probate. Each are a little bit different. Each have their drawdowns, have their positives. Living trust we'll talk about in a little bit. That's one way. Lifetime gifts, make the transfers now. They're out of your estate. They don't have to go through a will. They don't have to go through estate administration. Certain joint ownership property structures will circumvent probate. And then payable on death and transfer on death account designations, POD and TOD accounts. The easiest form is probably these account designations. So adding a POD and TOD designation to any account will allow the assets to be passed to the named beneficiary immediately on death of the account holder. There will be some paperwork. It could be a little bit of a hassle, but there's nothing holding the beneficiary from receiving those assets after the beneficiary has died, after the decedent has died. Great planning tool to an estate plan. These can be changed at any time. You're not stuck to them. They're not irrevocable. Anytime you have a change in your life situation, you can go in and recheck all your designations and make sure they still make sense. And this probably should be looked at quite often. I can't tell you, I've heard on more of a few occasions where husband gets remarried, never checked his TOD designations, everything was left to the former spouse, and there's really not much you can do about that after the husband passes. It's payable really to this beneficiary no matter what. So carefully review these designations and make sure they still make sense.
Oh,
sorry. Yeah.
Sorry.
Nope. So we'll talk a little bit about trust. Everybody's heard about these. Are really the most widely used estate planning tool for people regardless of wealth. Can fit into any estate plan. At its most basic level, a trust is simply an arrangement whereby one person holds legal title to an asset and transfers it into a trust and is managed for the benefit of another. It's somewhat works like a contract. Many uses for trust in financial and estate planning, but their ability to bridge the gap between life and death is one of its most powerful uses. So here we'll talk about a few of the uses. Among its many is it can be utilized to protect yourself and a spouse, as well as providing for a spouse and children after you have passed. They can address potential issues relating to children, whether it's minority age, immaturity, special needs, drug addiction, and abuse. They are also a measure to avoid probate, which we talked about. Since this isn't a trust, it doesn't have to go through the estate administration. One of the main tools in estate planning techniques for avoiding federal and state estate taxes. You can use trust to transfer assets in now, make those lifetime gifts, remove those appreciation out of your estate. There are several trusts that can be used to realize charitable goals, whether it's some of the more complex trusts, such as charitable remainder trust, or whether it's just determining how the assets are distributed after your death, whether you're going to name a charity for a portion of your estate residue to be distributed to. Protection from creditors. Trust can be drafted to keep assets out of your creditors' hands. It can also keep your beneficiaries safe from their creditors. This is one of the most, pivotal aspects of trust is really the protection for assets in general, but also from creditors. If you have a beneficiary who could be in financial or legal situations, judgments, divorce, business risks, this probably needs to be a part of your estate plan to make sure those assets are preserved. They can be used for Medicaid planning, keep assets away from elder care creditors. We'll talk about spendthrift provisions a little bit later, and it will allow a donor to transfer assets to a beneficiary while also shielding those assets from those beneficiaries' creditors if need be. And I know Lisa touched on a few of these, but I'll just kind of run through some of the main terminology and definitions that are pertinent to trust. First is the grantor, and this, you might hear the term settler, trustor, they mean the same thing. This is the person who starts the trust. The trustee is the person who will manage the trust. They will be bound by fiduciary duties, and they will need to act on behalf of the grantor, really as laid out or stipulated in the trust document. They can be anyone, family members, friends, banks, CPAs, attorneys. You will, of course, need to make them aware if you decide to choose them as a trustee to make sure they want to accept those fiduciary duties, and this is something that they want to take on. Beneficiaries, they will be the ones who have access to the trust income and who the principal belongs to. Trust can have a single beneficiary, multiple, and in this case, principal refers to the underlying assets of the trust, and the income refers to the income those assets generate. You may have a different beneficiary for income, and you may have a different beneficiary for the principal of the trust. They're not always the same, and in honestly most cases, they're usually different. And then powers, this pertains to the administrative powers of the trustee. We're going to talk about a few of them. Most are governed by the state law where the trust is domiciled, but there are some additional powers that can be based and put into trust documents based on the grantor's wishes. So there's many types of trust. They have all different uses. I think I'm going to talk about three here, the most basic, the most common, and really ones that can be used in everyone's estate plan. Living trust is just like it sounds. It's created during the life of a grantor. So assets will be transferred into a trust, and powers are retained by the grantor, so they will continue to control the trust. They'll still enjoy the benefit of the assets, and really nothing will change in their day-to-day lives. They'll get the income from the trust. They can use the assets anytime they want. They can change the terms of the trust, and for income tax purposes, nothing changes. It's considered a grantor trust, so you really carry on with your income tax return as you normally would. It's generally not a useful tool for reducing your gross estate if you have an estate tax issue. And this goes back to the power of control and the ability to access the assets. If you have this control, when you die, they're part of your estate. So it's not really an effective tool for mitigating any sort of federal and state estate taxes. The key here is when the grantor dies, that trust now becomes irrevocable. And the trustee, if in a living trust, you can name yourself trustee. If that happens, when you die, you'll have to name a successor trustee, and they will step in and manage and distribute those assets in accordance with the terms of the trust. One of the key benefits of living trust is the avoidance of probate. It eliminates the normal estate administration that would otherwise happen if everything was left through a will. It could also be useful in helping aging or incapacitated persons who want to turn management of trust assets over to a child or a trustee of their choice if they are, unable to keep up on their daily affairs themselves. So it will give, in case of a parents, if they set up a living trust and set their children as trustees, it'll allow their children to act on their behalf and manage those trust assets. So we see that a lot too. One of the drawbacks of a living trust is that, similar to how the assets will be included for estate tax purposes, this sort of trust arrangement will also not provide any level of asset protection. Your creditors will still be able to get this. Elder care creditors will still be able to access this. So your assets, you control them. So if you have any creditors, they'll be able to get their hands on the assets. Another hassle in setting these up is that you will have to go through the process of retitling all the assets that you would like to fund this trust with into the trust name, and that does take a little bit of time. Testamentary trust, as Lisa spoke about a bit earlier, are trusts created through a will, and they will take effect upon passing of a decedent. Instead of leaving assets to your children or desired beneficiaries outright, you can call for these assets in your estate to be left in trust for your children. If you are worried about your children, wasting their assets, frivolously spending them, testamentary trust is a great planning tool, as you'll be able to put some sort of control over how the assets are used, when they're used, once you pass. Many wills will create trust for grandchildren and limit how and when the money can be accessed and used. You can limit them to only receiving income for a certain period of time, or you can provide an age the child must reach before they can have access or a fraction of the assets of the trust. You can also direct what purposes distributions from the trust can be used for. We see a lot for the trust created for grandchildren, while they're younger and before the age of, 35, 40, and the trust indicates they might be able to receive the assets. Before they get to that age, they might be only able to use the trust for education, health. So it gives you some level of control that, your grandkids, who are probably young, won't be able to just access these assets outright and just spend them on luxury cars or jewelry and the such. So it just gives you a little bit of control and peace of mind after you die that your assets will be spent the way you intended. Again, similarly with living trusts, not a great tool for reducing estate tax exposure, since the trust does not take effect. Pretty far behind here. Since the trust does not take effect until you pass away, these assets are in your control. You can revoke it at any time. They're part of your estate. So I'll skip past a little bit more. Got 2 slides left. So the credit shelter trust. So this is a type of testamentary trust that will be effective for reducing estate taxes on the second to die spouse. It can be used for federal estate tax purposes, but really the key here and where we see it is the most for New York State residents who might be subject to the New York estate tax. So what this will do, if we take our example earlier, if a husband and a wife have a net worth of $10 million, creating a trust that leaves creating a will that leaves the entire amount to the estate of the surviving spouse is probably not the best play. There's no portability with New York. That wife is now, you're essentially kicking the tax bill down to your spouse, in which for New York, that entire $10 million will be taxable. Instead, a credit shelter trust will provide that a certain portion of the first to die's assets, up to the amount of the New York exclusion, are put into a trust. Normally for the benefit of their kids is the most common, and the remaining assets go to the spouse. So if we use that example of $10 million, the current New York estate exclusion is roughly 6.9. I'll create a trust, fund it with $6.9 million of assets. I'll have the assets, the principal belong to my children, and then I'll have that $4 million, the rest of the estate, transferred to my spouse as a marital transfer. When my spouse dies, now she only has $4 million of assets, because the rest I put in trust for the children. In that case, we really avoid the New York estate tax altogether, and the trust that I funded really with my kids as owning the principal, if I'm worried about my wife not having enough money when she's into her retirement years and I want to make sure she's cared for, I can call for the income of that trust that we set up to be paid to my wife. That's not going to impact her from a federal estate tax or New York estate tax situation, because she only has rights to the income, not the underlying assets, which typically we see those belonging to the kids. So that's a great tool, especially for New York estate tax purposes if you're within that, well, if you're close or exceeding that New York exemption. And we'll go through the last slide real quick here. So, after you die, and you might be concerned about making a trust that's too rigid, you're not enough flexibility. There are certain provisions you could add, which will give you, further peace of mind that if something happens, if your kids, things change, they have power to access money if they need it, have it be held back if they need it, just based on their, specific situations. One of which is income sprinkling. And this clause will give the trustee the power to distribute income to the beneficiaries at the trustee's discretion. Instead of having fixed income go out to each child in the trust agreement, you might want to add the income sprinkling clause. It's really, and a lot of times it's called as a parental substitute clause. It will give the trustee the power and the purposes to use their discretion to distribute to each of your children or designated beneficiaries as needed. Usually the grantor will give them some suggestions on what to use the money for, but they do have discretions on whether to pay out this income. So it's a little bit of flexibility there. The next is the use of trust principle. The trust will give the trustee discretion to use the principal or corpus of the trust for the benefit of the income beneficiaries. This is, in the estate world, it's known as a power to invade corpus. If the trust provides only for income distributions to be made for the beneficiaries. This power will allow the trustee to make distributions of trust principal to these beneficiaries if needed. Typically what we see is this follows the ascertainable standard, the HEM standard, which means anything for health, education, maintenance, or support. But if, absent this clause in the trust, if your kids really need income or they have a life event and they're only able to access the income from the trust and not the actual underlying assets, it might be too restrictive and it might not help them out, as you intended. There's also the power of a beneficiary to withdraw principal, and this a little bit works in reverse. If you stipulate that the trust is only able to distribute out income to your children, and you don't want them to be stuck with such a restrictive trust agreement and be limited to the income, you can add in a power that allows them to access a certain amount of the trust principal every year on an annual basis. Typically what we see is 5%, but again, this is just some more flexibility that, you want to make sure if your kids do really need the money, they can have access to some of it while still being within control. And on the flip side, there's also the holdback provision, which gives a trustee really discretion to, hold back the principal that per the terms of the trust would normally be allocated and need to be paid out to a beneficiary. And this would happen if there's drug or substance abuse problems, gambling issues, if the beneficiary is about to go through a divorce and he's turning 50 and the terms of the trust indicated at 50, he's going to have access to the entirety of the trust. This provision will allow an independent trustee to use discretion and hold those back if needed and not have to distribute those out, which could be problematic in certain situations. These are just a few of the most common. There's many more, but these are the ones that really provide the greatest flexibility for you as you work through your estate planning.
Great, we covered a lot of good information, got deep on some of it. So please, everybody, there is the question in your toolbar. Pop any questions that you have. While you're putting those in, I'm going to share one last poll question with everybody. And it's just a quick, easy one. Would you like to be contacted by Lisa or Adam this week on some follow-up of that? I'll let everybody fill that out. I will ask one of the questions that came in to Lisa. You had the AARP book there. I'm assuming they can just call or go on the website to get a copy of that.
Yes, I can actually give you the link if you want to put it in the email later. Great, with that information. Yep.
Awesome. I'm going to close out the poll in just a minute. It looks like some people are still voting. The other question that came in, can you add a payable upon death or transfer upon death designation?
Yeah, depending on the account, IRAs will typically have that. Most, brokers will offer that on investment accounts, but you should probably talk to, each of them have different sets of rules, but you might need to, first establish the type of asset and then talk to the custodian of that asset, but generally, yes.
Great. If anybody has any remaining questions, feel free to pop those in. If Lisa and Adam's contact information is up on the screen, so you can reach out to them directly also. You'll get an immediate survey to complete when the webinar ends. And then, like I said, I will send a copy of the presentation, link to the AARP booklet, and a link to the recorded session that you'll get this afternoon. Another question came in. Do you recommend clients add the gift rider to their POA?
I'm not familiar with the gift rider. I can get back to you.
Okay.
It might be more of a legal term that I just haven't dealt with much.
Okay, Sarah, we will get back to you one-on-one with that. And we thank everybody for joining us today. If you have any questions, reach out to us anytime, and have a great afternoon. Thank you, everyone.